Sometimes crazy just has to crazy. Let's talk about Zach Hughes' testimony. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. In the world of legal ethics, I've always believed that there are never any good answers, only intelligent choices. Because in the area of legal ethics, you don't have a choice between a good choice and a bad choice. Usually, you have to discern which of the two very bad choices you wish to make. I was reminded of this watching the calm testimony of Zachary Hughes during the trial yesterday. And I have a couple of thoughts about this. Why did his lawyers let him testify? Although most criminal lawyers can get their clients to listen to them when it comes to testifying in their criminal cases, Sarah Boone being a notable exception there, the fact is that the client, not the lawyer, gets to make the ultimate decision to testify or not testify. In nearly every trial, the judge will ask at the close of the state's case if the defendant intends to testify. He or she asks the defendant, if you're not going to testify, or if you are going to testify, was that your decision? Did you talk to your lawyer? Did you evaluate his advice? Were you promised anything? Did anybody threaten you? The judge gets all of this down on the record because he knows if he doesn't do that, some enterprising appellate lawyer down the road will swear on a stack of Bibles that the defendant was beaten with a truncheon to force him to testify or to prevent him from testifying. And he'll win an ineffective assistance of counsel reversal because the record doesn't speak to those issues. Here, the trial counsel, I am certain, advised him not to testify. And most likely, the reason he advised him not to testify is because the judge barred any evidence of the supposed rationale he had in executing this victim. Those of you who have been following the case know that after the killing, the boyfriend of the victim, Bradley Post, was charged with certain crimes of the type that we just can't talk about on here. But at the time of the murder, Zach didn't have any evidence that those things were going on. He only knew what the father, John Mello, had told him. He didn't have any independent evidence of anything bad going on. Specifically, the child that he was supposedly rescuing, which was John Mello's child, Mello was seeking custody from Christina Parcell because of some suffering at Parcell's hands. Now, it's difficult to believe, although it certainly is possible, that Parcell was involved in the activities that got Bradley Post arrested. But the remedy for that is Child Protective Services. The remedy for that is the sheriff's office or some other law enforcement agency to bring to light the allegations that are going on. It isn't to do the Ginsu routine on the mom. But having done the Lizzie Borden Act on Parcell, Hughes had to have a defense. So the defense that they agreed to was the defense of just cause. Probably because Zachary Hughes did not think he was a psychopath and didn't think he was crazy. But I'm not so sure. In fact, I'm actually kind of sure the other way. According to Hughes' testimony, Mello offered to pay him $5,000 for doing what he ultimately wound up doing. Hughes refused the money. He had his principles. If he was going to do this, he was going to do it because he was going to right a wrong. And so he just did what he did. The testimony was chilling. Watch the way he calmly sips water like he's discussing the best way to tie his shoes or some other unimportant thing. He clearly has contempt for the victim and even more contempt for the judicial process. Let's watch.
And Zach, you testified before lunch about two offers John had made you to kill Christina Parcell. Do you remember that?
I remember.
And do you remember after the second offer telling John something to the effect of, you would never do that for money. You would only do that if you believed it was necessary to rescue Aida.
And if I believed there was no other way.
Did you take Christina Parcells' life on October the 13th?
Yes, because I believed it was absolutely necessary to save Aida, and I was right.
Objection, Your Honor. Sustained. I ask you to disregard the testimony that you just heard.
I want to talk about the timing. You've alluded to it a little bit, but I want to be more specific. October the 13th. Describe for the jury why you felt that was the time, or why you believed it, or why it was necessary to do it on October the 13th, specifically, or in this period of time.
I had been wrestling with this since June. As I previously stated, since the end of June, I believed Aida was in complete and grave danger every moment of her life that she was living with her mother. And the other things that I had tried to do to save her from that were not working. So I was having this incredible wrestling match within myself for these months, feeling that I needed to do something to save her, and yet feeling this incredible reluctance to do the one thing that I knew would save her because of how terrible I knew it would be to do it, even though I believed it would be right. So by the time October 13th rolled around, I had been grappling with this for a long time, and I was experiencing a tremendous amount of guilt that I had waited as long as I did, because I should have acted sooner, and I didn't do that. So I had come to the realization that I had gotten this offer to go on this cruise ship, and I would have been leaving the country for a long time. Essentially, it was now or never.
Two things are immediately clear listening to this testimony. At least they're immediately clear to me. First, the man is a psychopath. And second, the judge was never going to allow this defense. Why is that? Well, the defense was trying to analogize this to the classic self defense situation where you're defending others. That is good law in pretty much every jurisdiction, although it has some nuance to it. A person who is being attacked and can use lethal force in self defense can be defended by another person to the same extent and to the same degree as the person being attacked. So let's talk about two scenarios. First, Veronica is coming out of the malt shop with a bag full of cash, having just pocketed the pistol she used to hold the place up. Now, Detective Archie sees the robbery through the window and is waiting outside, and he pulls his service weapon and yells at Veronica to stop. Now, clueless Jug heads over across the street, and he sees Archie in plain clothes pointing a gun at Veronica, who has never given him the time of day, and he kind of wishes she had. So, to see that that happens, he immediately pulls his own pistol and shoots Archie. In some states, like Alabama and I believe Florida, if Jughead truly believed that Veronica was at risk and he didn't know about the robbery and he didn't know that Archie was a cop, he would have a defense to the charge of murder because he really believed that he was defending somebody who couldn't defend herself. In Massachusetts, they'd throw him under the jail because Veronica would not have been privileged to resist lethal force by a police officer. In Alabama and Florida, because the situation was fluid and public policy wishes to encourage people to act in defense of others, Jughead would go free. In the northeastern states, the public policy is that life is sacred, and you have to be certain that the person you're defending, particularly with lethal force, is in the right before you act. Now let's look at a second scenario. Luke's sister Leia is married to Han, and Han likes to get drunk on Saturday nights and beat up Leia. One Saturday night, after his soccer team, Manchester United, loses a soccer game, Han assaults Leia, causing significant injuries, and he puts her in the hospital. Now, Luke goes to visit her in the hospital and vows that this will never happen again. So, when a tearful Han comes to the hospital to apologize for his behavior, Luke, fearing another attack, takes some violent action that results in Han's passing. Even though Leia has been seriously injured, that defense, the defense of others, will not work here. Why is that? Because there was no immediate threat. For self-defense to be an option, or for defense of others to be an option, there has to be a sudden, imminent, and unavoidable deadly threat, or a threat of serious bodily injury. Because Leia, if Han had come to hurt her, could have locked the door to her room in the hospital and called the cops, there was no immediate likelihood of injury or death. So Luke's going to jail. So again, in this situation, there is no immediate, imminent, deadly threat. And that's because this has been ongoing for months, and while it probably is serious bodily injury, he does not know, in fact, that it is happening. He has been told that it's been happening by another person, but he does not have any objective basis other than rumor to act on this action. So again, that defense is not going to fly. The idea that you have just cause to commit an act that he committed in cold blood, premeditated, it just doesn't fly. Now, I believe in this particular case that what is being done here is the lawyer is playing for an appellate review. He's going to try to change the law in South Carolina on defense of others. And he's going to say, sometimes in defense of others, you have to have the ability to take independent action. And I don't think that's going to work, because that essentially opens the door to anybody who wants to take the law into their own hands. And we don't let people take the law into their own hands in this country. It's why we have police. It's why we have a justice system. Now, if I'd been defending, I think I would have gone for an insanity defense. There is no question that Hughes did it. He admitted it on the stand. This wasn't a whodunit, it was a why'd he do it. And since the route to defense of others was blocked by a judicial order, the only smart thing to do would have been to plead insanity. But I started out talking about an attorney's ethical duties, and I'm sure that Zachary Hughes did not want to be labeled insane. And I'm also sure that he really, truly, honestly believed, even though it has no basis in fact, that he was acting to protect the child. In fact, he acted to protect the child in such a way and testified to that he got cited for contempt and sent to jail for 6 months, which is really ridiculous when you consider the fact that he's now got 2 life sentences. So maybe they're going to keep his corpse in a cell for 6 more months. I don't know. But I started out talking about an attorney's ethical duties. If you have a client who is under a disability and wants to take action that is against his own best interests, you have to act accordingly. Let's take a look at the rule. Now, this is the ABA Model Rule 1.14, and it says, when a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. In other words, take direction from the client, do what the client wishes to have done. When a lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken, and cannot adequately act in the client's own interest, The lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. It's pretty clear to me that he was under a disability. I can't say what that disability was other than maybe just delusions that this defense would work, but I'm not certain what I would have done as an attorney, so I really can't say anything about the person who represented him or the people who represented him. I think they did as good a job as they could do, given the client and given the facts. As we often say, you can't file a timely motion to change the facts in a murder case. At the end of the day, Zachary Hughes is where he belongs. He's in state prison in South Carolina. Maybe he got the cell right next to Alex Murdaugh. I don't know. But I can tell you this: you earn your way into a prison on a murder charge like he did. The crime that he committed was exceptionally brutal and heinous, and he's lucky he didn't get considered for the death penalty because what he did was truly an abominable act. The defense did the best job they could for him, but the job of the defense in a case like this is to make the state prove its case. It's not to offer false evidence or bad testimony, even though in some respects that's what happened. Their job is to make the state prove the case. The state clearly proved the case, and then he came in and admitted, hey, yeah, I did it, as a way of saying I did it because I had to. And that clearly, the defense of justification, had to do it because of this circumstance. I just don't think that was ever a rational approach to this problem. So that's what I have for you today. Thank you so much for watching. Come on back, join me down here on Monday. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.